way back in 2017, where among other things we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the general, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values, transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentality. Document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana wandema mire makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting lifting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head, the extent and reality of presidential power, by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation, the paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So, that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions, Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of deja vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobweze then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power was systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it of the commentary, because to my mind, the people of Kenya were quite clear that they were not going to cede the constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people creators of the Constitution were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is, with great respect, quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of, which is but an power with which the people themselves, acting directly, can both make and replace a constitution. I've quoted Nabweze. The Njoya decision, which Ringera actually quotes Nabweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's rumination on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The passion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he says, he gives an example of whether the Americans could decide and amend the first Constitution, the First Amendment, and replace it with an opposite fundamentally contradicting principle, such as establishing a state religion. Such a move would amount to a constitutional breakdown or revolution in the proper sense, and not a valid amendment of the Constitution. Professor Robert Albert, in an article called Constitutional Amendment and Dismemberment in the Yale University Law Journal of International Law, states that this Rawlsian view reflects the conventional understanding in the field of constitutional change. Either a constitution is amended consistently with the Constitution, or the alteration is so transformative that we cannot call it an amendment, and we must instead recognize that conceptually it creates a new constitution. Under that view, this would be the case even if the old constitution is not formally replaced with a new one. It can safely be argued that any amendment that alters the core aspects of a constitution, changing its character and ethos in a radical manner, is essentially changing its basic structure, and in all but word abrogates or dismembers the Constitution. The basic structure doctrine and the notion of constitutional dismemberment have the same effect of positing that such constitutional amendments are in fact unconstitutional. I've quoted the concurring opinion of Mr. Justice H.R. Khanna in Kesavananda, and I just want to mention that it's important to note that the Indian Constitution, just like ours, did not then and does not now contain unamendable provisions in its text. It lacks express limitations to its amendability. This is in contrast to some other jurisdictions in which the constitutions contain provisions prohibiting amendment of certain subjects, leading to the terminology, as Professor Raznai notes in his PhD thesis, the terminology of immutable, unalterable, irrevocable, perpetual, or eternal, all of which he considers, and I readily agree with him, to be inaccurate. Why? Because they imply everlasting provisions, but they are neither eternal nor unchangeable. While they serve as a mechanism for limiting the amendment power, they do not and cannot limit the primary constituent power. Moreover, their content can also change through judicial interpretation. The Brazilian terminology, which refers to these provisions as Petraeus clauses, which I understand, that's me, which I understand to mean founded on rock. Of the primary constituent power. Therefore, in order to describe the legal situation more accurately, I refer to these provisions throughout this thesis as unamendable, as opposed to eternal or eternity clauses. The scholar notes that the technique of expressing prohibiting the amendment of certain state features, be they the form of government, separation of powers, or the like, spread like a fire in a thistle field, or, if you like, in the Gikomba clothes market, and was impelled in part to protect the Constitution by guarding against what he calls popular levity and legislative caprice. He then concluded that just as having a form of constitution virtually became a symbol of modernism following the American and French revolutions, so too nowadays having an unamendable provision is becoming a universal fashion. But importantly, he points out, which is germane to the analysis whether the learned judges were wrong in arriving at the conclusion they did, that the amendment power must be conceived as implicitly limited, even in the absence of any explicit limits. And it traces this back to the United States back at the dawn of the 19th century, refers to the works of John Calhoun in 1851, who wrote a book called Discourse on the Constitution and Government of the United States, and then also Thomas Cooley's Stories Commentaries in 1893. All these speak to the notion of intrinsic limitation to the amendment power, and it is not much different from the basic desire of Kenyans, I referred to earlier, that their constitution be altered only by the same means by which they made it. In Germany, the scholar Carl Schmitt was of the same view, that no revision of the constitution could provide for the destruction of its legitimacy. In short, the constitution does contain a core of implicitly unamendable principles which embody its identity. According to Rosenai, the argument in favor of implicit limitations on amendment powers did not remain in the realm of theory, but migrated from political events. It was applied practically and most notably elaborated. I have indicated and traced the fact that that theory, doctrine, had an incremental fate in India. It was rejected in the case of Shankari Prasad versus India, and then it was again rejected in 1965 in the case of Singh versus Rajasthan. The first foothold of that doctrine was when a narrow majority of 6 versus 4 versus 5 of an expanded bench in Golaknath versus State of Punjab reversed those earlier holdings without invalidating the amendments in question. I need to mention here that those a German professor of Asian law that had been placed before the court by one of the petitioner's lawyers, one M.K. Mambior, and I have indicated that this goes to show the value of research. When lawyers do good research, you get good results in the judgments. Now, the Golaknath decision, however, unleashed the wrath of a furious Prime Minister Indira Gandhi and signified the opening shot of the Great War over parliamentary versus judicial supremacy, and I've traced all that. When we came to Kesavananda, there was an extraordinary bench of 13 Supreme Court judges, and a narrow majority of 7 to 6 held that the amendment power does not include the power to alter the basic structure or framework of the Constitution so as to change its identity, and this is the kernel, the heart of the basic structure doctrine. Now, the majority faced reprisals from Gandhi, most notable being that her breaking with custom to appoint Justice Ray, the senior-most of the dissenting judges, as Chief Justice instead of the senior-most judge of the court, who happened to have been in the majority. Now, in Indira Nehru Gandhi versus Raj Naram, 5 judges unanimously confirmed the basic structure doctrine in 1975. In of India in 1980, again, there was a unanimous holding that held that insofar as a certain section there removed all limitations on Parliament's amendment power, it conferred on it the power to destroy the Constitution's essential features or basic structure, and this was beyond the amendment power and thus void. Now, contrary submissions that were made before us, the basic structure doctrine, from my reading of the cases subsequent to Kesavananda, demonstrates an ascendant trajectory to the point that it is firmly settled as a doctrine in India. The split majorities of its inception gave way to consistent unanimous decisions of the Supreme Court, so that the so-called compelling case by R. Dhawan, said to be a respected advocate and leading Indian scholar, that Kesavananda ought to be set aside would seem to have no solid foundation in my respectful view. It has stood for more than 50 years, or about almost 50 years now. In Malaysia, for example, I have quoted 2 cases from Malaysia which seem to show that the doctrine was more accepted than repudiated. I have also taken time that taken note that other Asian countries such as Bangladesh and Pakistan have embraced and fully affirmed the basic structure doctrine. I've quoted some cases there. And citing various cases from far west, Central and South America, specifically Argentina, Belize, and Colombia and Peru, Rosnai comes to the conclusion that the basic structure doctrine has migrated far and wide across the globe. Some of the arguments that were made before us here were made in Belize, and the Supreme Court, in the case of British Caribbean, had this to say. They referred to the Indian basic structure and then said, though the Constitution of India is different in several respects from our Constitution, both constitutions have basic structures, features such as judiciary, rule of law, fundamental rights, and separation of powers. As I have stated before in this judgment, constitutional borrowing, cross-pollination, is perfectly legitimate and is the proper way to develop the law, while ensuring that whatever is borrowed is relevant, useful, and fitted to suit our particular circumstances. I need only add that the legal scholars have recognized and encouraged constitutional borrowing by courts for persuasive purposes, and there are all manner of articles. Can constitutional borrowing be justified? In the University of Pennsylvania Journal of Constitutional Law, and then constitutional borrowing in the Michigan Law Review. I note with a measure of bemusement that while castigating the learned judges for relying on foreign jurisprudence, the aggrieved appellants have laid before us numerous decisions of foreign courts. I was at first minded. I have mentioned some of the things that were quite off in the manner in which the submissions were made. We were told that cases said one thing when in actual fact they said something else. I'll give an example. In one of the submissions, it was said that in Uganda, the Supreme Court, in the case of Paul Semogerere and others, equally disquote a passage that I think was quoted by one of my colleagues this morning, about those who make the Constitution know what's good for them, etc., etc. And then, but now, this is what I say. Now, after reading, from a reading of that passage quoted by counsel, the impression is that all those words were by Mr. Justice Tesekoko of Uganda. But in truth, only the last paragraph contains his words. Now, having read the Semogerere judgment myself, which was usefully, if ironically, supplied by counsel in volume 8, I cannot but respectfully conclude that the case does not at all advance the appellant's particular argument or case. First of all, it turns out that the bulk of the excerpt attributed to Judge Tesekoko are not his words. They are actually words apparently found in a Kesavananda dissent, which the judge quotes not directly from the judgment, but as said to be quoted in a Singapore, puts it thus at page 8 of his judgment. He said, no copy of the judgment of Kesavananda case was availed to us. I have not been able to lay my hands on the full judgment, but passages of it are quoted in the Singaporean case of Sesolung. Now, with great respect, I cannot see how it is possible for Semogerere to have dismissed Kesavananda, as we are urged, when the judges deciding it had not even engaged with the doctrine and had not even read the judgment. In fact, nowhere in Semogerere is there a whiff of rejection of the basic structure doctrine, which is the heart and essence of Kesavananda. To the contrary, Tsekoko J indicated that in his considered opinion, Kesavananda case was misunderstood and therefore misapplied to the petition that was before the Constitutional Court. And then he talks about what he thinks Kesavananda, which he didn't read, was about. Now, I did not say anything on the judge's understanding of the issue in Kesavananda, which I, unlike he, have read in full. But it should be obvious that given the infirmities I have pointed out, Semogerere, as presented before us, cannot be a basis for the contention that the basic structure doctrine was rejected in Uganda. Easy, and others versus the Attorney General of Uganda, where seems to say, the judge said that the basic structure doctrine is still at a nascent stage of development. This is a 2018 decision, but from what I've said, the basic structure is not nascent, it's not new, it has actually grown quite old. Now, having undertaken so detailed an account and analysis of the Indian experience with the basic structure doctrine and its migration across the globe, I have no difficulty discounting those conclusions as untenable. I would also reject the decision cited to us of the Honorable Attorney General of Tanzania versus Christopher Mtilika, because there the court said, the Court of Appeal of Tanzania, it said that the courts must eschew a loosening of judicial discipline in interpreting the explicit provisions of the Constitution. And they went on to say that a tightening of judicial scrutiny would be necessary. Now, I think that is the very antithesis of what our Constitution requires of our courts. I cannot accept as a correct reading of the Constitution, less still a possessive one, for me to follow the conclusion reached there that everything is amendable once the procedure for amendment is followed and that the basic structure doctrine does not apply. The conclusion I have arrived at out of my forays into the jurisprudence and learning I have referred to, and much more besides, is that the basic structure doctrine is legitimate and sound. I would think it's strange that anyone would doubt the existence of a basic fundamental essential core, being the pillar upon which the Constitution stands and from which its character, ethos, and identity flows. There is a such. Any and every house, be it simple, complex, and elaborate, must have some structure with its bare essentials. Even as some houses have fewer items than others, going into their basic structure than others, so would different constitutions differ in complexity. I was pleasantly surprised to see that Joseph Raz, in a book called Between Authority and Interpretation, uses the analogy of a house to differentiate between minor changes to the Constitution, like redecorating a house, and major ones that alter its character. Rosemary refers to that very analogy of a house. I will not say much more on what he says. I cite the passage, I've cited a passage at length to signify my full agreement with the learned judges that the amendments proposed by the BBI initiative and bill were so far-reaching in character, foundation, they were effectively dismembering the Constitution, blasting so huge a hole in it as to pulverize its foundations and essentially create a new constitutional order. To do so would not be to amend the existing Constitution, and therefore there was need to resort to and summon the primary constituent power. The mere invitation of the people to vote on the radical transformative proposals at a referendum was not an effective summons of the correct authority, because the people acting on the amendment plane constitute the secondary constituent power only and are limited to amendment. They are in no position, while acting in that capacity and space, to endorse and effect a constitutional replacement. This latter they can only do in primary constituent mode. Now, Rosnai, I believe, asserts crucially that the amendment power is a constituted power even if exercised by the people. Moreover, no constituted power should be entitled to abolish the democratic system. To my mind, that is the cognitive posture that we should adopt in answering the question whether the notion of limitations to the amendment power discussed by so many courts loses any of its logical force by the fact that the amendments proposed in the case at bar and contemplated by Article 255 and 57 of the Constitution require approval by the people in a referendum. The conclusion appears to me inescapable that as long as what is contemplated is an amendment, it will ipso facto be limited. The limitation in this case stems from the fact that certain aspects of the proposed amendments unquestionably go to the essential core and fundamental fabric of the Constitution, thereby purporting to alter irredeemably its character and identity. Such radical alterations are not amendments in the real sense of the word, for there has to be a limitation to what amendments can achieve. And I would think that dismemberment is dismemberment, whether effected through surgical amputation or through rough mutilation. It matters not whether you cut or hew him as a carcass, either way. I have said enough, perhaps more than enough, to show that I do not think a sufficiently compelling case has been made to warrant our interference with the conclusion that the learned judges reached with regard to the basic structure, doctrine, and its applicability in Kenya. I have gone back to what Lenaola J had to say in the Commission for Implementation of the Constitution, was National Assembly. I am fully in concord with the reasoning. I'm so fully in concord with the reasoning of Lenaola J that I will not add a single jot or tittle to his reasoning. Having come to the conclusion that the basic structure doctrine is applicable, the conclusion is also inescapable that the amendment power set out in Article 255 to 257 of the Constitution is limited, and that the basic structure can only be amended through the constituent power. That constituent power can only be properly summoned and exercised in accordance with the four-sequence process of civic education, public participation and collection of views, constituent assembly debate, preceding a referendum. And this accords with the holding in Joya. I would hold without hesitation that a referendum cannot be effective as contemplated by the constituent power unless the initial three steps have been involved and engaged in real and substantive, as opposed to a ritualist and minimalist manner akin to a mere token ticking of boxes. Ringera J said, all in all, the limitation of Parliament's power was a very wise ordination by the framers of the Constitution, which is worthy of eternal preservation. The Platon proposed by the BBI Amendment Bill have the potential to alter by one fell swoop the fundamental pillars that define and undergird our Constitution. They are truly no less than a ballistic attack on our Constitution's foundations, including separation of powers, independence of the judiciary, and Chapter 15 commissions and independent offices, not to mention supremacy of the Constitution, sovereignty of the people, and the national values and principles of governance. I accept that this is not exhaustive and should be dealt with on a case-by-case basis. Ringera J indicated that we have been down this road before, but without judicial challenge. I surmise that a cowed populace probably did not have the courage to seek redress, nor was the judiciary back then particularly famous for the defense of the Constitution. For the superior courts of this country at this time, there is no luxury of indifference or neutrality. Where in former times no challenge to the manifest alteration of the Constitution's basic structure was made, is summoned to the valley of decision. Defending citizens have raised alarm at the threatened dismemberment of the 2010 Constitution. The High Court has, with crystal clarity of reasoning and felicity of dictum, raised a barricade against such a scheme, and it is upon this court to either raise the bulwarks of defense even higher and place around the Constitution a wall high and impregnable against such machinations, or, as we are urged by the appellants, we disable the brakes, uproot the ramparts, and usher in an open season for the systematic and unbridled dismemberment of the Constitution. To me, there's only one path that commends itself consistently with conscience and fealty to the constitutional command. I must defend it and keep its fortifications firm and effective. I must stand up for the Constitution, heeding the words of the hymn, where duty calls or danger, be never wanting there. I have referred to the aspect of illiberal democracy and its growth, and I've talked about Professor Rosalind Dixon and David Landard. The point they point out that the constitutional amendments or basic structure doctrine, though at times attacked as being anti-majoritarian and making courts too powerful, is in fact a useful tool to help preserve so-called fragile democracies against the democratic erosion that is inherent in abusive constitutionalism. Beyond textually stated eternity clauses, they point out that many scholars can be defended. Now, however, an exercise of the people's secondary constituent power, or as argued by some, an aspect of the constitutive power contemplated by the Constitution itself as part of its amendment procedure, I am better persuaded by the unconstitutional constitutional amendments to basic structure doctrine. I am justified by this view, by my appreciation that even referendum procedure can be made of no effect by a deficit of prior civic education and public participation. Indeed, someone has said that for populists, a referendum isn't meant to start an open-ended process of deliberation among actual citizens to generate a range of well-considered popular judgment. Rather, the referendum serves to verify what the populist leader has already discerned to be the genuine popular interest as a matter of identity. An effective bulwark against abusive constitutionalism, therefore, seems to me to be on the authorities, one that entails more as opposed to less people involvement. I think, therefore, that there is nothing anti-majoritarian or doctrinally abhorrent about the four-step process the learned judges held to be indispensable for effectuation of amendments of the kind proposed by BBI. It has to be recalled that the restriction to amendment need not be in express text. It is generally accepted that in keeping with the interpretive posture addressed earlier in this judgment and on a proper understanding of the basic structure doctrine, the limitation can be implicit. Therefore, it is the people themselves who preferred rigidity over flexibility. They were bothered by hyper-amendability, and for me, the numerous amendments proposed are no less offensive because they are presented in one bill at once and not through staggered installments over time. Justice Chandrachund in Casavananda stated that the basic structures theme, which the founding fathers have committed to your care, for you know best the needs of your generation, but the Constitution is a precious heritage, therefore you cannot destroy its identity. In short, it is undeniable that by using the basic structure doctrine, the judiciary does play an important role against democratic erosion, and I would, without hesitation, affirm the learned judges on the basic structure. My voice is running out, so I will just make a few comments on the other issues. Popular initiative. I have held that in the amendment scheme of the Constitution, it is clear beyond peradventure that as far as the characterization of the amendments to the Constitution go, there is a binary reality with two distinct, dichotomous and disjunctive initiatives, the parliamentary one or the popular one, each providing a distinctive methodology or procedure. And what appears clear from the Kenyan experience is that the popular initiative was introduced as a response to citizens' frustrations with Parliament, to whom the law-making power is delegated. It was not always acting in a quite inimical to the interests of the public. The popular initiative is therefore a mechanism for the people to exercise direct authority in the amendment of the Constitution. It is a power reserved to them as the sovereign to do that which Parliament may have defaulted in doing. This is consistent with Article 1, Sub-Article 2, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Admittedly, this form of active, direct, and deliberate democracy is quite new in the African experience, but has been around for quite a while in other parts of the world. Referred to variously as the Constitutional Initiative, mainly in America, or Citizens' Initiative in Europe, it has certain discernible characteristics which are pointed out. Now, one of the things to note is that in an article by Maya Setale and Theo Schiller, editors, Citizens' Initiatives in Europe, Procedures and Consequences of Agenda Setting, the author draws a valid and useful distinction between compulsory referendums, which are for constitutional changes, popular initiative, which allows for any other proposal on the table. By the term popular or citizens' initiative, we refer to procedures that allow citizens to bring new issues to the political agenda through collective action, that is through collecting a certain number of signatures in support of a policy proposal. The role of these citizens' organizations, social movements, civil society organizations, etc., they are the ones who lead the citizens. The role of these organizations outside of formal representation through Parliament is the answer to the political marginalization of the citizens, famously expressed by Jean-Jacques Rousseau in the social contract this way, and which might have universal application. He said, the English people, and you could put any other people there, the English people think that they are free, but in this belief they are profoundly wrong. They are free only when electing members of Parliament. Once the election has been completed, they revert to a condition of slavery. They are nothing. End of quote. It includes in the perspective other optional plebiscites which are identified as presidential, governmental or parliamentary initiatives. And these are contradistinguished from the direct democratic perspective that trusts in the people to initiate the direct decision-making process. In this range, we have the popular initiative, the popular referendum initiative. From my reading of the literature on these subjects, I am fully fortified in my view, which coincides with that of the learned judges, that a popular initiative is a citizen-conceived, citizen-initiated, and citizen-driven process. And these are the ordinary mwananchi. No matter how well-intentioned, it ceases to be a popular initiative and must be recognized and named a state or presidential initiative. Now, in answer to the question whether what happens when the president has a parliament that doesn't listen to him, I do not doubt that the president, with his wide array of powers and influence, could have used the parliamentary initiative through his party and others with whom he with which he works, or could work in a coalition of the willing to bring about the changes to the constitution that he seeks. The president's role in the conception and initiation of the Building Bridges initiative is writ large, and with it the panoply of power and prestige of his office. First was the handshake, then the BBI Gazette, which was appointed by task force was appointed by Gazette, which is an official government publication. The task force prepared a report which it presented to the president as president and commander-in-chief. Moreover, the president again appointed a steering committee on the implementation of the ABA report by way of a special issue of the Kenya Gazette, state lodge, that everything about the process. It was a presidential government project, and this was wholly antithetical to the popular initiative. Like Machiavelli's prince, the president's conduct is different from that of ordinary citizens. In acknowledging this plain and in spirit of fact, one does not thereby curtail the president's enjoyment. One might even say deployment of his personal or political rights. All it means is that the space upon which he elected to exercise his rights is reserved for ordinary citizens, the common populace of the Republic of Kenya, and it is not open to the president. It is out of bounds to him. The question is, first of all, hypothetical, but to my mind, the president does not shoulder any obligation to initiate constitutional changes. He takes office under and in accordance with the Constitution, and his duty duty is to obey and defend it in keeping with the oath of allegiance, not to change it. It follows from my reasoning that I agree with the learned judges that insofar as the President took certain actions at the inception of the BBI process, including appointing the task force and later the steering committee by gazette notices in his capacity as President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the popular initiative path, a preserve of the ordinary citizen, was not available to him for initiating any amendments to the Constitution. I would dismiss the grounds of appeal challenging that finding. Next, jurisdictional objections. I do not think there was any merit in the claim that the matters were either sub judice or were res judicata on that point. Let me rush quickly to the legality of the BBI process. I've said things there that initially that already give an answer to this, but given there was never indication, I should start here. A number of critical facts stand out in crystal clarity from that gazette notice which appointed the steering committee, regarding the steering committee which, taken singly, together or wholly, go to declare that it was a presidential creation and a government project tasked with inter alia proposing constitutional changes for the implementation of the report of that very team in its previous emanation as the BBI Advisory Committee, and the facts are there, I've stated them. Given there was never any indication that citizens of this country had, in and by themselves, conceived of the idea to change the Constitution in a particular manner as the genesis of this process, but appear only to have been roped in to respond to what had already been given life and motion by the President when he appointed the task force, the process that was being undertaken was not a popular initiative. And it matters not that it may eventually have gained the liking or admiration of many people. That sense of popular is not what is meant by the Constitution, which uses popular in the sense of pertaining to the general public or ordinary citizens. The BBI Steering Committee, by inception, composition, and operationalization, was a government presidential project. The members were not ordinary citizens who came together, coalescing around an idea that the Constitution needed to be changed in particular respects. Instead, these were prominent personalities joined together by presidential fiat. They had no mind or idea of their own to initiate, but were instead tasked to identify constitutional, among other changes. It was not open to them to purport to craft constitutional changes and even come up, they were without untenable for them to seek to camouflage their process as a popular initiative, which it was not. They were essentially seeking to hijack the People's Initiative route under Article 257 of the Constitution, and this was clearly intolerable and indefensible. It was also contrary to the letter and intent of the Constitution. That, I think, provides the answer to what I had to say about that aspect. Yes, I think I am dealing with, yes, public participation is the next point. And under public participation, I have indicated the Constitution itself, a product of super participation on the part of the people of Kenya, recognizes participation of the people as one of the national values and principles of governance. It is listed in Article 2A alongside patriotism, national unity, sharing and devolution of power, the rule of law, and democracy. I have no hesitation holding that participation of the people is what gives meaning to and serves as the guarantor to the tangible realization of the other values and principles of governance. It is what gives substance and brings to life as a present reality the idea that democracy is a system of government of the people, by the people, for the people, as famously put by US President Abraham Lincoln in his Gettysburg Address on November 19, 1863, which he hoped shall not perish from the earth. Participation by the people is in the matters that are our own destiny. Their autonomy, individually and as a collective, is mainstreamed, even as the paternalistic state and its officers that so easily assume the position of ex cathedra directives recede to a facilitative as opposed to a command position. Once the people are involved in policy formulation, legislation, and in the greatest, most solemn role of constitutional amendment, they get to own both the process and the product. They are no longer pawns on a political chessboard. They are not mere voting machines at the beck and call or political operatives. They are not commodities for sale to the highest bidder. They retain ultimate control over government and are not at the control of government. The Constitution says so, and it is the duty of those who enforce or interpret the Constitution to give real meaning to the principle in its widest and fullest manifestation. Now, I have said many more things about public participation, but long and short, yes, there's an aspect. I agree with the judges generally when they talk about public participation, but whereas the above reasoning is perfectly in line with the public participation, with what it would require in a matter of such moment as constitutional amendment, I must express my unease, brought out quite poignantly by Mr. Karori in his address to us, that it would be to place an onerous and well-nigh impossible burden on promoters of a constitutional amendment by popular initiative to expect them to go the whole hog, captured in the above excerpt, including translating it into all the languages, having it in Braille, etc., and sending it all over the country. That to ask them to do that before they collect the signatures might be a bit too onerous. It seems to me, with respect, that the requirement stated by the judges must be present before or at the time of the voters finally make their decision on the proposed amendment of the referendum, failing which the mandatory requirements for public participation will not have been met, with fatal consequences to the proposed amendment. I am of the view, however, that the elements of public participation stated must perforce be understood as incremental in character. It would be way too expensive. Amendments, be it by way of a general suggestion or a formulated bill, must engage and involve the voters generally, by which the landed judges must be understood to mean the national vote pool, from whom the promoters would be seeking the 1 million supporters, to the broad and extensive elements of public participation enumerated by the landed judges. I think that the duty they bear at that point of signature collection is one of sensitization with candor and disclosure, as opposed to one of full broadcast by all means in all languages to all voters of the full particulars of the exact amendments by way of the amendment. It is enough that a voter should know what is sought to be introduced by amendment in sufficient detail to be able to make a decision whether it is an initiative he would support by appending his signature at that stage or not. To that extent only would I respectfully fault and reverse the learned judges while leaving intact their reasoning and holding on public participation with regard to the totality of the process up to the referendum. Of course, it has been argued that why worry about public participation? The way you look at everything else, the way it is set out, there will be enough moments for public participation, and perhaps the judges acted too fast and too soon. And I think, with respect, that whereas on paper the argument does sound attractive, the reality on the ground, as became apparent during the hearing of the appeal, is that there was a measure of cynical disregard for the very opportunities and timelines intended to facilitate public participation. Even for the signature collection, for instance, it turns out that the IBC apparently published the list of the persons listed as supporters of the initiative to facilitate confirmation by the people that the list was accurate, thereby seeming to involve them. This was in reality a mere show, devoid of substance, however, for the reason that the list was published by the IBC on the IBC website only, and then the public were informed of the fact on Thursday, 21st January, and were required to have notified IBC of any complaint by the following Monday, with a weekend in between, to access information available only on a single platform. Under those circumstances, it sounds rather strange for IBC to point at the apparent absence of complaint as demonstrative of accuracy or satisfaction. It could well have been due to absence or, at the very least, insufficiency of access. Another glaring and troubling example that was cited in argument before us was the lightning speed at which the amendment bill was rushed and passed through county assemblies. The Constitution deliberately indicates that they are to consider the bill within 90 days. And it is argued that properly and properly so, that the period is intended to facilitate public participation, which I take to take the form, at the minimum, of publication of the bill within the county, followed by consultation, receipt of memoranda, debate in public forums organized for the purpose, and on other platforms, so as establishing whether or not to support or approve the bill, was a farcical disregard for the people and the Constitution. Many county assemblies made absolutely no pretense to involve the citizens resident in their counties, spurred on no doubt by certain incentives beneficial to themselves, the most notorious of which was their demand for some 2 million shillings car grant, which was quickly granted by government. The usually slow and tight-fisted Salaries and Remuneration Commission, despite well-known fiscal challenges and a raging global pandemic, somehow managed to prioritize, approve, and find funding for that particular incentive for MCAs, which seems to have attained the status of a national emergency. What in the end seems to have happened in county assemblies was a mad rush to demonstrate personal gratitude and party loyalty, with some passing the bill in but a couple of days. The people did not matter. They might as well not have existed. And no superior court in this country, properly directing itself on public participation, would in conscience accept as permissible such violation and negation of the constitutional scheme and command to put the people first and center in public affairs, of which amendments to the Constitution is definitely the most solemn. I would affirm as correct the holding of the learned judges that county assemblies are under a duty to approve or reject a constitutional amendment bill in a popular initiative whole without amendment, so as to maintain and preserve its content and character inviolate as a popular initiative. It is also the more reason why they are under a clear duty to be scrupulously and faithfully discharged, to involve the people so as to discern which way they should vote on the amendment bill. On presidential immunity, all I will say, first of all, is that there was an issue that His Excellency the President, Uhuru Kenyatta himself, it would have been neater. It would have been neater if the President himself joined the proceedings and raised objection to his having been sued in his personal capacity. But he was not. Now, the issue that arises that he appears not to have been served, and I might as well state at this point that the learned judges ought, at the very minimum, to have first satisfied before proceeding to hear and determine the matter, and to even make pronouncements against him. This is a fundamental and basic tenet of natural justice, and the rules as to service or process are quite explicit as to what is required to have been done. I therefore agree with Mr. Gatonyel, Senior Counsel, that any adverse orders made against the President in his personal capacity would be open to setting aside ex debito justitiae. That does not mean, however, that the learned judge's finding on the extent of the President's immunity from civil suit is also affected, because this is a matter of constitutional law, not personal to the sitting President. And I have quoted Article 143(2), and the argument was that the President should be impeached in case of things that happen outside of his immunity. Now, as an impeachment can be challenged in courts, it was counsel's view that it was putting the cart before the horse for the courts to entertain suits against the President in his personal capacity before he gets impeached. When seeking clarity, I asked counsel the hypothetical question of what my neighbor out in the village of Karaos, Kesogon, Trans Nzoia County would do were I the President and my dog beat his child. It was counsel's confounding answer that the only recourse open to my neighbor was to seek my impeachment. He cannot be right, not least because there is nothing presidential about such a canine indiscretion that would only invite tortious liability. Counsel drew the attention of the court to Article 165 of the Constitution that gives judges immunity, and in particular the case of Bellevue Development Company and Francis Gikonya and 7 others. I am familiar with it. I wrote a judgment in it. But the position I take is that the protection that is given to the president has to be purely functional, related to his office, and does not extend to any matters that are done outside or in violation of the Constitution. In fact, from my analysis, it is possible to state the law on presidential immunity to be this: the president is immune from criminal prosecution and from civil suit for any act or omission in exercise of his powers under the Constitution in Kenyan courts during his or omissions for international crimes where the treaty establishing them does not recognize the defense of immunity. The statutory limitation period shall be extended to take account of any action or suit that could not be brought on account of the defendant's presidential tenure. I make a distinction between this and the immunity that the president had under the old Constitution, where it was absolute. And I would say that absolute immunity, which existed under Section 14 of the retired Constitution, appears to me to be an anachronism and an oxymoron in the context of a constitutional democracy such as we are, that upholds as part of its national values and principles of governance the rule of law, good governance, integrity, and accountability. Those values and principles, alongside constitutionalism, which denotes limited government, denotes limited government, must mean that the office of president, being a creature of the Constitution, is and must be subordinate to the Constitution, and its holder must be held to account for his acts and omissions. The president is not above the Constitution or the law, and is not a law unto himself or herself. In recognition of that preeminence and importance of the office of the president, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143.2, and the fact that Article 143.4 expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president, Richard Nixon, was held to have was from damages liability predicated on his official duties, official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue here, coming out of petition number 426 of 2020, are those acts which are said to have been committed by the president outside his constitutional powers and in fact in contravention of the Constitution, and the land judges held, and I would respectfully affirm, that the president is not immune from suit for that. I only need to add that the days of an accountable presidency are long gone and are of only historical significance as a lesson and a warning to the citizens of the country to be vigilant and to demand accountability from the person to whom they entrust the responsibility of leadership. Experience, as recorded in many cases, the courts. I hold that the appeal challenging the landed judges holding on presidential immunity from suit in personal capacity should fail. Regarding the legal regulatory framework for constitutional amendments by popular initiative, I have mentioned some of the arguments that were made, and I would say that I think it's a matter too plain for argument that the country does need a referendum act, and there is none at present. The landed judges were informed that there was a proposed referendum bill somewhere in the legislative pipeline, but there seems to be uncertainty as to its eventual fate. So, it's interesting that, and odd that the Attorney General, who should have been at the forefront in seeing the legislation is in place, the IBC, which needs it for proper conduct of referenda, and the BBI Secretariat, which needs it to be guided by it if it were to pull through the proposed amendments, all seem to speak the same strange language, that the gaping lacuna is of no significance or moment. With great respect, I do not find such a stance by critical players in a national exercise to be of great importance to be particularly helpful. And I do hold the view that candor in public affairs, including in litigation, is a virtue to be embraced. It cannot be right for parties to propound in court positions they know to be so plainly untenable, and to do so without batting an eyelid. That this country needs a referendum act is an urgent matter and should have been addressed years ago. Now, the Attorney General went on to assert that all motions involving the furtherance of popular initiative are an exercise of citizens' political rights as enshrined in Article 38, but they should not be limited by flimsy excuse of lack of regulations, administrative procedures, or statutory prescriptions not expressly provided for under the Constitution or legislation. That's what the argument was. Whereas the Attorney General is quite right that the enjoyment of fundamental rights cannot be conditioned upon the enactment and promulgation of any statutory rules or regulations, with the absurd result adverted where rights are held at ransom by official neglect, I do not think that the landed judge's decision was to that effect. I fear the Honorable Attorney General, quite the opposite. At paragraph 6 or 3 of their judgment, said that even if there is no referendum act, it is still possible to under proper with proper adherence to the Constitution, to go right ahead and hold a referendum. I think, with respect, that given the uncertainties, ambiguities, and penumbras that are apparent in the manner in which one is to go about initiating, collecting signatures, forwarding, debating, involving the public, campaigning, and voting on a popular initiative for the amendment of the Constitution, together with the necessary timelines, this area is in a wholly unsatisfactory state and needs clarity by way of both national referendum law and probably rules and regulations specific to the popular initiative. It is disingenuous for it to be argued otherwise, unless uncertainty in law should somehow have attained a utility I myself cannot discern and state as of a virtue. I am firmly persuaded that a referendum in the context of proposed constitutional amendments by popular initiative must be governed by a specific, properly thought out legislation. It cannot be left to the Elections Act, which seems to contain a part of the referendum in some kind of by the way or afterthought, regard having heard to the fact that referendums are not elections and they are no less important than elections. I would go as far as to state that whereas the provisions on referendum in the Elections Act may suffice to settle questions of various types and descriptions in an ordinary referendum, they are not sufficient in detail and clarity and were not formulated to meet the full requirements of Article 257. I should think, with respect, that it speaks to a national malaise of inattention to duty, a satisfaction with dilatoriness, and being reactive instead of proactive on the part of officialdom, that the referendum law has never been passed, notwithstanding Nyamoya Jay, as she then was, had spoken of its glaring need in the case of Republic versus County Assembly of Kirinyaga, ex parte Kenda Muriuki, and another. Now, in resolving this issue, the issue of verification, I've gone into some depth about it. All I can say that the report was even more emphatic. This is a report that was done by IBC itself in the Okoa Kenya initiative, was even more emphatic on the process of verification, which must entail ascertainment that the status of the supporters as voters and of the authenticity of the signatures as theirs. I agree entirely with the sentiments of the judges, safe to say that the landed judges were perhaps too magnanimous in having been merely startled by IBC's flip-flopping on this rather straightforward matter of what it means to verify. I should think that such shifting of goalposts probably smacked of candor economy, calling for stern rebuke. It is a matter of utmost importance that all persons and institutions that appear any other contrary stance bring the administration of justice to disrepute and must not be condoned or normalized. And therefore it boggles the mind that with regard to the BBI proposed amendments, IBC sees its role as different from what it stated with regard to the Okoa Kenya initiative. In sum, there does exist, with regard to the counterpart electoral processes, full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IEBC lacked the requisite legal and regulatory framework in the specific issues of signature verification, and that the stopgap administrative procedures were invalid, were unassailable, and I will not interfere with them. On IEBC quorum, I think a lot has been said. I am in total agreement with my brother Justice Gatembu when he came to the conclusion that the quorum of IEBC cannot be 3. The quorum of IEBC must be 5. And to my mind, such a vital role done by IEBC requires the full complement of IEBC with all hands on deck. It is to me another instance of officials' failure on the IEBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear doing just fine. The Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IEBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted, and IEBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, I would therefore agree with and affirm the landed judges holding that all the decisions made by IEBC in relation to the proposed constitutional amendments via the BBI amendment bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IEBC had managed to register some 108,000 more voters up to the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say, and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden, because it is the IEBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the Constitution, it is this very greatest stake to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore, when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Kriegler Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. But first of all, the argument was made that we judges, the judges should not have told the IEBC how to go about it, because that is trying to control them. But I suggest that I do not understand independence of commissions to mean that they are anyway beyond being told by the courts what the law is. Now, if I may pause here for a moment, it becomes clear that some amendments to the Constitution do not require the involvement of the people generally at a referendum. And one of the problems of the IEBC bill is that it contains both matters that require a referendum and others that do not. It contains multiple and altogether way too many proposed amendments, some of which would require a referendum while others do not. The confusion becomes intolerable in that a bill is prepared containing provisions that from their different proposed impacts requires two different tracks for enactment. Indeed, because of the numerosity of the questions, I think I have said that I do not for a moment think that it was ever the intention of the people that amendments to the Constitution should be the normal done thing whenever we feel the urge. It should come rarely, and even then, when amendments should come singly, once, rarely. If for any reason, and I cannot readily conceive of any, amendments must be brought other than singly, the original intent must be maintained by having each amendment presented separately and distinctly to be voted upon independently. That way, the choice presented to the people is not a binary one, and the people do not have to feel railroaded into choosing what they do not like alongside what they like, or vice versa. That Hobson's choice may perhaps be avoided by way of a multi-option referendum, but I will refrain from making any conclusive findings on it in the absence of a referendum act, the desirability of which I have already addressed under the rubric of legal and regulatory framework. I have taken the view that whereas Section 49 of the Elections Act does envision multi-question referendum, I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single object. On the whole, therefore, I do find and hold that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the delegation of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency, apportionment, and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise, and regarded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2008. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus the Republic. It resonates with what I stated earlier when treating of the basic structure doctrine, that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and present danger of violation or contravention of rights, or an unlawful tinkering with or alteration of the Constitution's basic structure, such as portended by some of the provisions of the BBI Amendment Bill. The courts, when moved, must take defensive action in aid of the Constitution, even by making a preemptive strike that ensures of day. I have again seen refer to Mr. Karori's arguments in which he talks about the difference between the power of IBC over wards and over constituencies, which I agree with, but a careful reading of the judgment does not suggest to me that the learned judges held that the number of constituencies cannot be altered. I think they stated the opposite, and quite emphatically and unambiguously so, which again I have quoted them. What the learned judges did hold was that it was impermissible for the BBI Amendment Bill to directly allocate and apportion the 70 extra constituencies it created without the delimitation exercise that is commanded and provided for in detail to be undertaken by IBC in Article 89, which lists and Article 88.4, which lists the delimitation of constituencies and wards as one of the particular, and I dare say, exclusive responsibilities of IBC. To my mind, the protective role of independence commissions over the sovereignty of the people is of critical over the delegation of the sovereignty of the people is critical and vital importance and can only be attained by a jealous and uncompromising assertion, exercise and defense of their independence. Independent commissions are charged with the duty of vigilantly and keenly ensuring that the state organs to which sovereign power is delegated maintain the stance of delegates accountable to their principles and remain always the servants of the people. And therein lies the absolute necessity of the independence of those commissions being kept firm and inviolate. I would thus hold that seeing how critical the independence of independence commissions is to the sovereignty of the people, it has to be part of the basic structure of the Constitution, which is given express amplitude by entrenchment. Having the BBI amendment bill to be an unconstitutional attack on the independence of the IBC and materially seek to alter by the operation of various of its provisions the limitation scheme set out in Article 891 of the Constitution. It effectively attempts to repeal that provision without saying so by stealth and subterfuge. Now, it is a statement to the thoroughness of forensic analysis and intellectual engagement the learned judges brought into this aspect of the case, as indeed the entire case, that they proceeded to expound on in some detail on each of the 6 reasons or markers of unconstitutionality that they identified in the BBI bill. I'm not to go into them. As I am myself fully satisfied with the accuracy and logical legal foundations of those reasons, I do not consider necessary to rehash them. The conclusion is inescapable that being so violative of the Constitution, the provisions of the BBI amendment bill were benighted and ill-fated at inception and had to be struck down as null and void. As to the cross appeals, I am in full agreement that both of them should fail, and that's my position. And so, finally, in conclusion, I would express my deep gratitude to all counsel and parties who appeared before us. The depth and extent of learning that went into the preparation of these appeals and cross appeals by both sides of the divide was truly impressive. The authorities were numerous and the workload quite daunting, and I must commend the industry and commitment on display before us. The erudite submissions made passionately and with persuasive force exemplify the importance of oral advocacy at the bar by both seasoned seniors and talented young legal eagles. The latter exemplify Chinua Achebe's quip in Things Fall Apart that when a child washes his hands, he gets to eat with kings. These young lawyers will soar to great heights, and should they maintain the discipline, hard work, courtesy, and professionalism that was in prodigious display before. It is safe. It says textbooks, articles, commentaries, and other authorities were in their scores, running into hundreds, nay, thousands of pages. It was not possible to refer to each and every one of them, just as it was not practical to quote verbatim all the submissions made before us for days, not to mention the hundreds of pages of the same in writing. My not having referred to any of them is no indication of their lack or worth of work or importance, but merely the function of limited space and time. In the end, I trust that we have all kept the Constitution safe and secure on this occasion, and may it always remain so. Thank you.
Well, thank you, my brother Justice Kiage. It is now about 10 minutes to 5, so we'll take 10 minutes health break, then come and finalize the remaining judgments.
preeminence and importance of the office of the president, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143.2, and the fact that Article 143.4 expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, that each act must be shown strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president Richard Nixon was held to have was from damages liability predicated on his official duties, official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue here, coming out of petition number 426 of 2020, are those acts which are said to have been committed by the president outside his constitutional powers and in fact in contravention of the Constitution, and the learned judges held, and I would respectfully affirm, that the president is not immune from suit for that. I only need to add that the days of an accountable presidency are long gone and are of only historical significance as a lesson and a warning to the citizens of the country to be vigilant and to demand accountability from the person to whom they entrust the responsibility of leadership. Experience, as recorded in many cases, both local and comparative, shows that in a democracy, no office is immune from accountability to the law as administered by the courts. I hold that the appeal challenging the learned judges holding on presidential immunity from suit in personal capacity should fail. Regarding the legal regulatory framework for constitutional amendments by popular initiative, I have mentioned some of the arguments that were made, and I would say that I think it's a matter too plain for argument that the country does need a referendum act, and there is none at present. The learned judges were informed that there was a proposed referendum bill somewhere in the legislative pipeline, but there seems to be uncertainty as to its eventual fate. So, it's interesting that, and odd that the Attorney General, who should have been at the forefront in seeing the legislation is in place, the IBC, which needs it for proper conduct of referenda, and the BBI Secretariat, which needs it to be guided by it if it were to pull through the proposed amendments, all seem to speak the same strange language, that the gaping lacuna is of no significance or moment. With great respect, I do not find such a stance by critical players in a national exercise to be of great importance to be particularly helpful. And I do hold the view that candor in public affairs, including in litigation, is a virtue to be embraced. It cannot be right for parties to propound in court positions they know to be so plainly untenable, and to do so without batting an eyelid. That this country needs a referendum act is an urgent matter and should have been addressed years ago. Now, the Attorney General went on to assert that all motions involving the furtherance of popular initiative are an exercise of citizens' political rights as enshrined in Article 38, but they should not be limited by flimsy excuse of lack of regulations, administrative procedures, or statutory prescriptions not expressly provided for under the Constitution or legislation. That's what the argument was. Whereas the Attorney General is quite right that the enjoyment of fundamental rights cannot be conditioned upon the enactment and promulgation of any statutory rules or regulations, with the absurd result adverted to where rights are held at ransom by official neglect, I do not think that the learned judge's decision was to that effect. I fear the Honorable Attorney General appears to have misapprehended the reasoning of the learned judges, which was quite the opposite of the meaning he ascribes to them. In fact, judges at paragraph 6 or 3 of their judgment say that even if there is no referendum act, it is still possible under proper, with proper adherence to the Constitution, to go right ahead and hold a referendum. I think with respect that given the uncertainties, ambiguities, and penumbras that are apparent in the manner in which one is to go about initiating, collecting signatures, forwarding, debating, involving the public, campaigning, and voting on a popular initiative for the amendment of the Constitution together with the necessary timelines, this area is in a wholly unsatisfactory state of and needs clarity by way of both national referendum law and probably rules and regulations specific to the popular initiative. It is disingenuous for it to be argued otherwise unless uncertainty in law should somehow have attained a utility I myself cannot discern and a status of a virtue. I am firmly persuaded that a referendum in the context of proposed constitutional amendments by popular initiative must be governed by a specific, properly thought out legislation. It cannot be left to the Elections Act, which seems to contain a part of the referendum in some kind of by the way or afterthought, regard having heard to the fact that referendums are not elections and they are no less important than elections. I would go as far as to state that whereas the provisions on the referendum in the Elections Act may suffice to settle questions of various types and descriptions in an ordinary referendum, they are not sufficient in detail and clarity and were not formulated to meet the full requirements of Article 257. I should think with respect that it speaks to a national malaise of inattention to duty, a satisfaction with dilatoriness, and being reactive instead of proactive on the part of officialdom, that the referendum law has never been passed, notwithstanding that some 2 years ago, Justice Nyamweya had spoken, Nyamweya J, as she then was, had spoken of its glaring need in the case of Republic versus County Assembly of Kirinyaga, ex parte Kenda Muriuki, and another. Now, in resolving this issue, the issue of verification, I've gone into some depth about it. All I can say that the report was even more emphatic. This is a report that was done by IBC itself in the Okoa Kenya initiative, was even more emphatic on the process of verification, which must entail ascertainment that the status of the supporters of the status of the supporters as voters and of the authenticity of the signatures as theirs. I agree entirely with the sentiments of the judges, safe to say that the landed judges were perhaps too magnanimous in having been merely startled by IBC's flip-flopping on this rather straightforward matter of what it means to verify. I should think that such shifting of goalposts probably smacked of Kanda economy, calling for stern rebuke. It is a matter of utmost importance that all persons and institutions that appear before court be careful to be entirely forthright. Any other contrary stance brings the administration of justice to disrepute and must not be condoned or normalized. And therefore it boggles the mind that with regard to the BBI proposed amendments, IBC sees its role as different from what it stated with regard to the Okoa Kenya initiative. In sum, there does exist with regard to the counterpart electoral processes full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IBC lacked the requisite legal and regulatory framework in the specific issues of signature verification and that the stopgap administrative procedures were invalid, were unassailable, and I will not interfere with them. On IBC quorum, I think a lot has been said. I am in total agreement with my brother, Justice Gatembu, when he came to the conclusion that the quorum of IBC cannot be 3. The quorum of IBC must be 5. And to my mind, such a vital role done by IBC requires the full complement of IBC with all hands on deck. It is to me another instance of officials' failure on the IBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear a brave face and state in legal proceedings no less that it's doing just fine. A more honorable stance would have been for the IBC and the Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted and IBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, oh yes, I would therefore agree with and affirm the landed judges holding that all the decisions made by IBC in relation to the proposed constitutional amendments via the BBI amendment bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IBC had managed to register some 108,000 more voters up to the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden, because it is the IBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been an unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the constitution, it is this very segment of the citizenry, the very youngest of adults, who have the greatest stake in the matter, and everything should be done to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore, when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Critical Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. But first of all, the argument was made that we judges, the judges should not have told the IBC how to go about it, because that is trying to control them. But I suggest that I do not understand independence of commissions to mean that they are anyway beyond being told by the courts what the law is. Now, if I may pause here for a moment, it becomes clear that some amendments to the Constitution do not require the involvement of the people generally at a referendum. And one of the problems with the IBC bill is that it contains both matters that require a referendum and others that do not. It contains multiple and altogether way too many proposed amendments, some of which would require a referendum while others do not. The confusion becomes intolerable in that a bill is prepared containing provisions that from their different proposed impacts requires two different tracks for enactment. Indeed, because of the numerosity of the questions, I think I have said that I do not for a moment think that it was ever the intention of the people that amendments to the Constitution should be the normal done thing whenever we feel the urge. It should come rarely, and even then when compelled by the greatest necessity. And for that reason, an amendment should come singly, once, rarely. If for any reason, and I cannot readily conceive of any, amendments must be brought other than singly, the original intent must be maintained by having each amendment presented separately and distinctly to be voted upon independently. That way, the choice presented to the people is not a binary one, and the people do not have to feel ramroded into choosing what they do not like alongside what they like, or vice versa. That Hobson's choice may perhaps be avoided by way of a multi-option referendum, but I will refrain from making any conclusive findings on it in the absence of a referendum act, the desirability of which I have already addressed under the rubric of legal and regulatory framework. I have taken the view that whereas Section 49 of the Elections Act does envision multi-question referendum, I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single amendment at a referendum for the people to either approve or reject. On the whole, therefore, I do find and hold that the landed judges were right in holding that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency, apportionment, and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise undergirded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IIBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2007 post-election debacle. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus Republic. It resonates with what I stated earlier when treating of the basic structure doctrine, that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and
Chapter 16 of the Constitution. The consolidated appeals before us arise from consolidated petitions that were filed in the High Court challenging the exercise of these provisions. My brother, President Musinga, has already given that background, and therefore I will not go into it. The issues that were raised in the appeals are many, and as I've already explained, I will just focus on the areas that I have some arguments which differ or which are approaching the issue differently from the others. And so I will add my voice on a few select issues. This is the basic structure doctrine and its applicability to Kenya, the remit of a popular initiative under Article 257 of the Constitution, the legality of the BBI process and the President's involvement, and the propriety of the proceedings against the President. I will not go into the submissions because that has already been done by my colleagues. So I'll go straight to the issue of the basic structure. What is the basic structure doctrine? In my earlier portions of the judgment, I had referred to definitions by Professor Yaniv Rosnai, Professor Beatrice Conrad, Professor Ben Obweze, and also the way it was explained in the Kasavananda case. And drawing from these definitions, I think that simply put, the basic structure doctrine is a principle according to which the power to amend a constitution is expressly or impliedly limited to constitutional amendments that do not alter or change the basic structure of a constitution. In India, the doctrine has been applied as limiting the amendment power of Parliament to alter or change the basic structure. Beatrice Conrad made reference to any amending body organized within the statutory scheme. And Professor Yaniv Rosnai extends the limitation to the exercise of constitutional legislative power and expresses the view that amendment power is sui generis, as it is neither a pure constitutional power nor an expression of original constituent power, and that it is an exceptional authority, yet limited. from these definitions. First, that a constitution has a basic structure. And second, that amendment of the basic structure by any amending body under the Constitution is not permissible if it will substantially alter or destroy the basic structure or identity of that Constitution. And consequently, a limitation on the power to amend the basic structure will be inferred. The challenging in considering whether the basic structure doctrine applies to a constitution is to unpack this basic structure in relation to the constitution. In other words, what is the basic structure in reference to that constitution? How does one identify the basic structure of the constitution so as to come to the conclusion that the intended amendment will alter or change that basic structure, such as to bring the basic structure doctrine into play? The general complaint that has been leveled against the judgment of the High Court in regard to the finding at paragraph 474F, which I have quoted in my judgment, but which I will now not read. The general complaint is that the foundational structure described by the judges as covering preamble, the 18 chapters, and the 6 schedules of the Constitution essentially means that the basic structure covers the whole Constitution. To use Ugandan Chief Justice Katurebe's illustration, which he gave in the Mabarizi appeal, the description of the High Court would not only include the foundation, the pillars, the walls, and the trusses, but even the roof, the doors, and the windows. A strict interpretation of the basic structure doctrine with this understanding of the basic structure would mean that the basic structure of the Kenya Constitution would literally consist of the whole Constitution. And therefore, it would be saying the whole Constitution cannot be amended in a way that alters or changes the Constitution. Indeed, the honorable judges of the High Court were of the view that such an amendment can only be done through the exercise of the people's primary constituent power. In my judgment, I have examined what Professor Nobweze says on sovereignty and the exercise of primary constituent power. And I've also looked at the adoption by Ringera J. in the Njoya's case of what Professor Nobweze says. And I'm in agreement that the people, in exercise of constituent power, can abrogate their constitution or make a new constitution, and that the exercise of that constituent power demands the participation of the people through civic education, public participation, constituent assembly debate, consultation and public discourse, and finally, this is the exercise of the primary constituent power as explained by Professor Nobweze, Professor Rosnai, and applied by Justice Ringera. As defined by Professor Rosnai, primary constituent power is what Ringera J addressed in considering whether Parliament had powers under Section 47 of the former Constitution to make amendments that would result in the repeal or abrogation of the Constitution or the enactment of a new Constitution. In this regard, Ringera J was categorical that Parliament has no such powers. Ringera J concurred with the position in the Kasavananda case that Parliament has no power to amend or change the basic features of the Constitution or abrogate and enact a new one. And I'm in agreement with this position, which is a position that was adopted by the learned judges in the High Court. However, it is important to note that Ringera J did not address the exercise of secondary constituent power in regard to an amendment initiated by public initiative, as the Constitution, as it was then, did not provide for it. In my view, the people can exercise their sovereignty in constitution making through their secondary constituent power by either delegating to Parliament or reserving to themselves the power to amend the Constitution. This is what the framers of the Constitution did in Articles 255 to 257 by delegating the power to Parliament to amend the Constitution under Article 256, Subarticle 1 to 5, through a parliamentary initiative, and allowing the people to exercise their reserved powers to amend the Constitution through a popular initiative under Article 257. This means that the popular initiative is a citizen-driven process. In both instances, the people remain involved in both the popular participation and are the ultimate determinant through the referendum process on whether the amendment is carried. The Constitution of Kenya 2010 also empowers Parliament to exercise constituted power under Article 94(3) of the Constitution in regard to amendment of constitutional provisions other than those mentioned in Article 255. It is necessary to interrogate the express constitutional provisions that donate amendment power so as to determine the extent of the powers provided, especially as relates to the amendment of the basic structure. The starting point for such an interrogation must be an understanding of amendment of the Constitution and a distinction between amendment and dismemberment or change and remaking of a Constitution. In the judgment, I have looked at several definitions of amendment and dismemberment, and from these definitions, it is clear that an amendment is an alteration of the Constitution that is carried out within the confines of the existing Constitution. Secondly, it alters the Constitution in a way that does not radically change the nature of the Constitution, which means it must remain areas have been identified in Article 255, and I have reproduced them in my judgment. I will not go through them now. But it appears to me that the framers of the Constitution, either consciously or unwittingly, identified the basic structure of our Constitution through Article 255. In my view, the thematic areas that have been identified are crucial and form the pillars of the Constitution. For example, without the thematic areas of the supremacy of the Constitution, the territory of Kenya, and the sovereignty of the people, the document would not have its identity and would be a completely different document from what was envisaged by the people and the framers of the Constitution. Without the national values and principles of governance, the Bill of Rights, and the independence of the judiciary, the Constitution would be a hollow document, not protecting the rights of the people or serving the interests of the people of Kenya as was intended. That is to say, that the framers of the Constitution of Kenya 2010, conscious of these thematic areas as the main pillars forming the basic structure of the Constitution, nonetheless provided a leeway for amendment of these thematic areas, putting in place appropriate safeguards, including the people's participation and final decision on the amendments. This is a clear indication that in regard to amendments, the Constitution of Kenya 2010 is explicit and self-sufficient. The key question in considering whether the basic structure doctrine applies in Kenya is whether, notwithstanding the express provisions for constitutional amendment contained in Chapter 16 of the Constitution and the limitations imposed therein, additional implied conditions that limit the amendment power can be inferred relying on the basic structure doctrine, and whether there are any eternity clauses or provisions of the Constitution that are unamendable. As my brother Judge Gatembo stated, the concept of a basic structure is not a new concept in our jurisdiction. Like him, I have also identified a few cases where this concept was discussed by the courts. And from the submissions that were made before us, it is clear that the issue of constitutional amendments is a topical issue that has elicited opinions, debates, and scholarly writings from jurists and academicians. It has also been subject of litigation in several jurisdictions. In discussing constitutional amendments, the paradox of unconstitutional constitutional amendments has come to the fore. Like the opinion of doctors, the opinion of legal experts is divided. Some in agreement, others in disagreement. Legal and academic writers in the academic discourse give us theory of what the ideal constitution should look like and what should be the aspiration in making the constitution. But constitutions are like human beings. They are never perfect. Each constitution responds to different circumstances in a social setup that is not necessarily the same as another. Constitutions cannot therefore be the same. Many times, as happened during the constitutional review process in Kenya, compromises and concessions have to be made in order to arrive at an agreement. Furthermore, although the people make the constitution with assistance from experts, the views of experts, important as they are not always followed. These are all important factors in this article obligates an interpretation of the Constitution in a manner that not only promotes its purposes, values, and principles, but also advances the rule of law, the human rights and fundamental freedoms, and permits the development of the law and contributes to good governance. Thus, the Constitution must be interpreted in a balanced way that achieves all these aims. As already noted, Article 255 provides a limitation to the amendment power in the identified thematic areas. It provides a higher threshold for alteration of any part of the basic structure identified in Article 255. Such amendments can only be done within the constitutional boundaries so that the amendment does not distort or deviate from the original purport of the Constitution. Under Article 257, the people can call in their reserved secondary constituent amendment powers through a popular initiative. But the exercise of that power must remain subservient to the Constitution because it is a power that, unlike the primary constituent power, emanates from the Constitution. The amendment must serve the Constitution to the extent of developing it without deviating from its original purport. The amendment must remain faithful to the Constitution. The exercise of the secondary constituent power under Article 257 of the Constitution through an amendment by a popular initiative is not inconsistent with the basic structure doctrine, though slightly different from the application in India, to the extent except that the power is expressly provided for in the Constitution, and the amendment initiative neither originates from Parliament nor does Parliament have the final say. The amendment process provided at Article 257 is inclusive, as it not only involves the people in its initial stages, but also provides room for participation of Parliament and the National Assembly, and the people retain the power of approving the final product at the referendum. It is therefore an amendment that is done by the people, but with a limitation that being a secondary constituent power, it is subservient to the primary constituent power and must remain true to the original purport of the Constitution. At paragraph 47G, permit me just to read just a little to put the whole thing in context. The learned judges of the High Court stated that there are certain provisions in the Constitution which are inoculated from any amendment at all because they are deemed to express categorical core values. And these provisions are therefore unamendable. These provisions can also be termed as eternity clauses. And then they say an exhaustive list of which specific provisions in the Constitution are unamendable or are eternity clauses is inadvisable to make in vacuum. The learned judges go on to give Article 2.1 and 2.5 as examples of unamendable clauses or an eternity clauses. But according to Professor Rosnai, unamendable provisions limit the holder of the constitutional amendment power in exercising its power to certain constitutional subjects, principles, or institutions. Professor Rosnai also posits that unamendable provisions may also generally protect the spirit of the Constitution, spirit of the preamble, fundamental structure of the Constitution, or nature and constitutional elements of the state. The Constitution of Kenya has not specifically identified any particular clause as an unamendable clause or an eternity clause. Therefore, as admitted by the learned judges, there are no express eternity clauses or unamendable provisions in the Constitution. However, as already noted, there is restriction of amendment power in Chapter 16 of the Constitution, unamendable, because the Constitution has provided for amendability subject to the limitations indicated in Chapter 16. The question is whether, as contended by the learned judges, there are certain provisions in the Constitution that are inoculated from this amendment power because they express core categorical values. As there is no express provision for unamendability, is there justification for the conclusion by the learned judges that some provisions of the Constitution are unamendable? While I disagree with the learned judges' position that there are unamendable clauses in the Constitution, I find the argument by Professor Rosnai that there may be a general implicit unamendability that runs through the Constitution to protect the original purport and spirit of the Constitution persuasive. This is consistent with the sentiments expressed by the learned judges in two of the cases that were relied upon by the judges of the High Court and which I have reproduced in my judgment for purpose of clarity. But I will just mention them here. There was the United Democratic Movement versus Speaker of National Assembly and others, which is a South African case, and which they talk about the preamble to our Constitution is a characteristic task, but profound recordial of where we come from, what aspirations we espouse, and how we seek to realize them. And then it goes on, but I will not read it. Then similar sentiments were also expressed by the Tanzania Court of Appeal in Dianabo versus the Attorney General, where they said, among other things, that the Constitution of the United Republic of Tanzania is a living instrument having a soul and a consciousness of its own, as reflected in the preamble and fundamental objectives and directive principles of state policy. In interrogating the original purport and spirit of our Constitution, my first port of call is the preamble to the Constitution, which I have reproduced in my judgment, but I'll not read. in the interest of time. The preamble indicates that the Constitution is the exercise of the sovereignty of the people of Kenya in determining their form of governance to meet their aspirations for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. It also shows their commitment to nurturing and protecting the well-being of the individual, the family, communities, and the nation. It also shows the sustainment of their heritage, their commitment to sustainment of their heritage and environment for their benefit and that of future generations, and the fostering of peace and unity as one indivisible sovereign nation. These aspirations and objectives are the purpose and spirit of the Constitution that must remain alive in the implementation of the Constitution. The exercise of any legislative power to enact an amendment that is contrary to the purpose and spirit of the Constitution will not pass muster. That is to say that although all the core parts of the Constitution are amendable under Chapter 16 of the Constitution, there is an implied limitation that amendment of the Constitution will only be permissible if compliant with the purpose and spirit of the Constitution. In this regard, I respectfully disagree with the position taken in the decision in the South African case of KwaZulu-Natal and others versus President of the Republic of South Africa, where it was stated that the reliance upon the spirit of the Constitution is misconceived, and that once the procedure in the amendment process is adhered to, the amendment is constitutionally unassailable. I disagree with that. In my view, any proposed constitutional amendment must pass muster both the procedural, in both the procedural and substantive tests. Accordingly, the fact-intensive determination that was adverted to by the High Court should not be one to determine the unamendability of any particular constitutional clause or core parts of the Constitution, but a substantive examination of constitutional amendment if it does not meet the substantive test. This can well be illustrated by the examples that were given by the first to fifth respondent at paragraph 282 of their petition that was filed in the High Court. For instance, an amendment to Chapter 2 of the Constitution to divide Kenya into two would fall into the thematic area of supremacy of the Constitution and would be contrary to the people's determination as espoused in the preamble to live in peace and unity as one undivided nation. Secondly, an amendment of Chapter 10 to abolish the judiciary would be contrary to the aspirations of Kenyans for a government based on essential values of justice and the rule of law. Another example, an amendment of Chapter 4 to abolish the right of an accused person to a hearing would be contrary to human rights, justice, and the rule of law. An amendment of Chapter 1 to relinquish control over Kenya to Uganda or any foreign power would be contrary to the people's sovereign power and their determination to live in unity as one indivisible foreign nation. So the examples are purported amendments that touch on the basic structure of the Constitution as identified through the thematic areas stated in Article 255, Subarticle 1 of the Constitution. The purported amendments may meet the procedural strictures provided under Chapter 16 of the Constitution, but would not meet the threshold of the general implied unamendability in regard to the spirit and purport of the Constitution as revealed in the preamble. It is also instructive that the preamble to the Constitution is not a constitutional clause that can be amended. It's an introductory statement which remains the reference point in terms of the Constitution's aims and objectives. It is therefore what I can describe perhaps as the GPS from which each constitutional clause gets direction, and any amendment must be measured accordingly. So with all that, my finding on the basic structure, rather my conclusion on the basic structure is, first, that the Constitution of Kenya has a basic structure which has been identified by way of thematic areas in Article 255, Subarticle 1 of the Constitution. Secondly, Chapter 16 of the Constitution provides for amendment of any part of the Constitution including the basic structure, and no express and amendable constitutional provisions or eternity clauses have been provided in the Constitution. And finally, the basic structure doctrine is applicable in Kenya to the extent that the exercise of secondary constituent power and constituted power to amend the Constitution is impliedly limited by the Constitution as evident in its spirit and purport, and therefore the exercise of amendment powers under Chapter 16 of the Constitution is impliedly limited, as such amendment must conform to the spirit and purport of the Constitution. Now, turning to the meaning and purport of a popular initiative under Article 257 and its constitutional remit. Article 257 of the Constitution provides for an amendment for relying on the definition from Wikipedia, a free online encyclopedia created and cited by volunteers, created and edited by volunteers. On my part, I have sourced the definition from Black's Law Dictionary, 11th edition, in which initiative has been defined. And that definition, which I will not read in the interest of time, that definition concurs with the Wikipedia definition which the High Court adopted. So, in other words, their reliance on Wikipedia was inconsequential. From the above definition, it is apparent that an initiative is a process through which voters take control by compelling a vote on a specific legislation. This means that the process must be a process initiated by a voter or voters as opposed to their representative. The definition is consistent with Article 257 that requires a promoter of the bill to galvanize support for it and establish that it is supported by at least 1 million registered voters. The definition is also consistent with Article 1, Sub-Article 2 of the Constitution that provides that people may exercise their sovereign power either directly or through their democratically elected representatives. Now, I've also looked at the American equivalent of which is referred to as the American equivalent of a popular initiative, which is referred to as a constitutional initiative. And this is how Professor Albert Stern describes it. The constitutional initiative is a technique of constitutional reform which affords a means of supplementing amendment by legislative proposal. It is not intended to replace the older method of altering state constitutions, but merely to provide an instrument whereby the people acting directly may inaugurate change. It continues, but I'll not go on. Then, looking at the history, we see that in the final report of the Technical Working Group of the Constitution of Kenya Review Commission, which was quoted by the Attorney General on the historical background, it reveals the same thinking, because it was stated that the committee introduced a novel idea called popular initiative, and this is an innovation where the citizen can, on their own motion, initiate amendment to the Constitution by a way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. So the framers of the Constitution, having provided under Article 256 for a parliamentary initiative, it follows that the second avenue of a popular initiative was intended for the people and not their representatives, such as members of parliament or the president. The word promoter has been used in Article 257, 3 and 4, where the promoter is obligated, respectively, to formulate a general suggestion into a draft bill and to deliver the draft bill and the 1 million supporting signature to IEBC. Black's Law Dictionary has defined the promoter and the voters to support the idea. In line with the objective of a popular initiative, such a promoter must be an ordinary citizen and not a parliamentarian or a state officer. So my finding on the popular initiative is that I concur with the learned judges of the High Court that a popular initiative is an initiative of the ordinary citizenry as opposed to the law-making bodies, and that it is intended to be used where the law-making bodies are unable or unwilling to act. Neither the President nor any state organ can initiate an amendment through a popular initiative under Article 257. Another issue is whether a constitutional amendment through popular initiative calls for public participation. This one, I will not go into it. I think it has already been discussed. The issues and the arguments have been made by my other colleagues, my brother and sister judges who have already given their judgments. And indeed, I come to the same conclusion that there must be participation, and not just participation, there must be meaningful participation. So I'm in agreement with the learned judges that public participation is one of the principles of good governance, and that it's a constitutional right that must be complied with at every stage of a constitutional amendment process. And in particular, I have said that it's particularly crucial at the commencement of a popular initiative, because the people must have appropriate information regarding the initiative to enable them make an informed choice on whether to support the bill or not, on whether to support the initiative or not. And therefore, the adequacy of public participation at the outset is very crucial. For if the people are not well informed and properly engaged, then the initiative cannot be a citizen process. One other issue with regard to participation, the appellants argued that it was for the respondent who are alleging that there was no public participation to prove this fact. However, under Section 112 of the Evidence Act, it is provided that in civil proceedings, when any fact is especially within the knowledge of any party to those proceedings, the burden of proving or disproving that fact is upon that party. If there was public participation carried out in regard to the popular initiative, this was a fact that was within the special knowledge of the appellants who are promoting the Amendment Bill 2020. The appellants cannot therefore shift the blame onto the respondents to prove the fact of public participation. No evidence was laid before the court to prove that there was any meaningful public participation before the collection of signatures in support of the proposed constitutional amendments. And I therefore uphold the finding of the learned judges that the BBI Steering Committee, as the promoter of Kenya Constitutional Amendment Bill, failed to comply with the key constitutional requirement of giving people information and sensitizing them prior to the collection of signature, and this rendered the process constitutionally unsustainable. With regard to the procedure in the county assemblies and parliament, it has already been referred to by my colleagues, and I concur that the mandate of the county assembly in interacting with the public initiative is only to consider, at that stage is only to consider and either approve or reject the draft as Amendment Bill 2020, originated from a process that has become commonly known as Building Bridges Initiative, BBI. This process was commenced through a handshake between His Excellency the President and Honorable Raila Amolo, and it was followed with the appointment of Building Bridges to Unity Advisory Task Force by His Excellency the President, Uhuru and Kenyatta, whom I refer to herein as the President. It is apparent that the President was at the forefront in the facilitation of the BBI process, including the appointment of the BBI Advisory Task Force and the BBI Steering Committee. The Gazette notices were duly signed by the head of public service, confirming that the appointments were made by the President in his official capacity. While the respondents submitted that the President abused his powers in engaging in the BBI process, the appellants asserted that in facilitating the BBI process, the President was exercising his authority under Article 131E, as read with 131(2)(c) of the Constitution, in promoting and enhancing the unity of the nation. And Article 131E states that the President is a symbol of national unity. 131(2)(c) gives him the authority of promoting and enhancing unity. So the process leading to the handshake between the President and Honorable Raila Odinga, the formation of the BBI Advisory Task Force and the BBI Steering Committee, and the consequent amendment bill is, in my view, akin to the National Accord or Peace Initiative that was signed on 25th of February 2008 between former President Mwai Kibaki and his erstwhile rival, Honorable Raila Odinga, with a view to implementation of a reform agenda to bring peace and address the recurrent conflict in the country. As explained in the Kivuitu case, which I've quoted and referred to there, the signing of the National Accord resulted in the former President appointing an independent review commission under the Commissions of Inquiry Act, whose mandate included examining the constitutional and legal framework for the conduct of elections, the organization and management structure of the Election Commission of Kenya, and its capacity to conduct electoral operations with a view to recommending electoral reforms. The Commission presented its report to President Mwai Kibaki on 17 September 2008, in which it recommended fundamental amendments to laws governing conduct and management of elections. The report, commonly known as the Kriegler Report, resulted in the enactment of the Constitution of Kenya Amendment Act No. 10 of 2008, which disbanded and replaced the Election Commission with an interim independent electoral commission. So this particular law was challenged in the Kivuitu case, and that is one case where the issue of the exercise of the presidential power came up also. The learned judges in the judgment and appeal rejected the plea of res judicata and plea of sub judice in regard to the legality of the appointment of the BBI Advisory Task Force and the BBI Steering Committee for the reasons that have been stated by my brother Musinga, President, and I'm in agreement with the learned judges that the doctrine of sub judice did not apply. One of the terms of reference of the BBI Steering Committee, published in Gazette Notice number 264 as 1B and reproduced at paragraph 549 of the impugned judgment, was, and I quote, to propose administrative policies, statutory or constitutional changes that may be necessary for the implementation of the recommendations contained in the task report. And I underline the words propose and the words or. The mandate of the BBI Steering Committee in this regard was first to propose changes. In other words, the committee was to make proposals for change. Black's Law Dictionary 11th edition defines proposal as something offered for consideration or acceptance. A suggestion indicated that the changes did not necessarily have to include constitutional changes. Thirdly, it was not part of the mandate of the BBI Steering Committee to implement the constitutional changes, if proposed, but to give advice on how such changes should be implemented. Thus, the purported distinction between the BBI Advisory Task Force and the BBI Steering Committee did not exist, as the BBI Steering Committee was not established for the sole purpose of initiating and promoting constitutional changes. Although the Third Way Alliance case related only to the appointment of the BBI Advisory Task Force, the issue raised in that case substantially related to the President's powers to appoint a task force or committee. In that regard, the finding on that issue relates to the appointment of the BBI Steering Committee, which was appointed before that judgment, as much as it relates to the BBI Advisory Task Force. More so, because the mandate of the BBI Steering Committee, as appointed, did not include initiating and promoting constitutional changes. In short, the matter before the High Court regarding the legality of the appointment of the BBI Steering Committee was res judicata and not open for consideration by the learned judges of the High Court. In the impugned judgment, the learned judges of the High Court found that the appointment of the BBI Steering Committee was unconstitutional, as there was no evidence that the President had complied with the provisions of Article 132(4)(a). I have considered these findings against the rival contention that the President was exercising his authority to engender peace pursuant to Article 131. Given the background to the BBI process, as I've already adverted to, the initiative leading to the BBI process was not any different from the peace accord that was signed between President Kibaki and Honorable Raila. No evidence was produced to show that the appointment of the BBI Advisory Task Force and the BBI Steering Committee was approved by the Public Service Commission as required under Article 132(4)(a). However, both committees, that is, the BBI Advisory Task Force and the BBI Steering Committee, were ad hoc committees appointed to advise the President. The appointments were actually officially gazetted under the hand of the head of public service, Mr. Kinyua, and I'm in agreement with the position stated by Mativo J. in the Third Way Alliance case that the authority of the President in Articles 131 and 132 of the Constitution ought not to be constrained as long as the exercise of that power is rationally related to the purpose for which the power was given. The President cannot therefore be faulted for initiating the BBI process, appointing the BBI Advisory Task Force and the BBI Steering Committee in an effort to foster unity, which is an initiative that was within his constitutional mandate. Furthermore, Article 256 and 257 provide for amendments by way of a parliamentary initiative and a popular initiative, respectively. These articles provide for the constitutional procedures that has to be followed in procuring the constitutional amendment. They do not provide for proposals for making an amendment by a parliamentary or a popular initiative. Obviously, before the drafting and promotion of a parliamentary or popular initiative, a lot of preliminary work has to be done. There is nothing that prevents the procurement and consideration of proposals for amendment by any person. The President was therefore free to obtain proposals for constitutional change from any quarters, including the BBI Steering Committee. Such proposals could have been used in lodging a parliamentary initiative or even a popular initiative by appropriate persons, following the appropriate procedures provided under Article 255 and 257. The BBI Steering Committee, having given its proposals on changes, which included a proposed constitutional amendment bill, its mandate was expended at that stage. For these reasons, I find that the learned judges not only erred in considering the legality of the BBI Steering Committee as the issue was res judicata, but also erred in finding that the BBI Steering Committee was unconstitutional and an illegal entity created to perpetuate an unconstitutional purpose. The formation of the BBI Task Force and the BBI Steering Committee all appear to have been done in good faith to achieve that purpose. Constitutional changes by means of an amendment to the Constitution which is a process that has been reserved for citizens. His role in amendment of the Constitution is at the tail end of the process as provided under Article 2565 and 2579 of the Constitution. And this is, in his capacity as President, to assent to an amendment bill once passed by Parliament or the people through a referendum. It was all well for the President to appoint the BBI Steering Committee and receive the recommendations for legislative and constitutional changes. But having done so, the President ought to have engaged the government machinery or his party in pursuing these changes through the appropriate channel, possibly a parliamentary initiative. As already indicated, BBI was a peace initiative by the President. The appointment of the advisory task force and the steering committee included the experts and the drafting team that backed these committees, all confirm that BBI was an executive-driven process and not a citizen-driven process. Although I disagree with the finding of the learned judges that the BBI advisory task force and the steering committee were unlawful, with their finding that these committees were unlawful, I find that the BBI steering committee had no capacity to promote a bill under Article 257. The bill was published as the Constitution of Kenya Amendment Bill 2020. The bill, which was published as a Constitution of Kenya Amendment Bill 2020, was dated 25th November 2020, and the promoters indicated as Building Bridges Initiative. Under Article 257, the promoter of a popular initiative is the one required to formulate it into a draft bill and thereafter deliver it to IEBC with supporting signatures. Dennis Waweru, who described himself as co-chairperson of the Building Bridges to a United Kenya National Secretariat, BBI Secretariat, swore an affidavit in which he claimed that the BBI Secretariat was a mover of the amendment bill and the process intended to amend the Constitution through a popular initiative. Although it was contended that the BBI Secretariat is a voluntary political alliance, there was nothing that was laid before the High Court to confirm this or to establish the existence of the BBI Secretariat or to connect it to Building Bridges Initiative that was indicated on the bill as the promoter. As found by the High Court, the drafting of the Amendment Bill 2020 was done by the BBI Steering Committee and was the culmination of the BBI process initiated by the President. There was no nexus established between the two co-chairs and the BBI process, such as to confirm that the two co-chairs were the promoters of the Constitutional Amendment Bill. In any case, Honorable Junet Mohammed, who is a current sitting member of Parliament, did not qualify to use the popular initiative route. Both the President and Honorable Raila continued popularizing the BBI process and encouraged the collection of signatures in support of the constitutional change proposed through the BBI process. And so the attempt to distinguish the BBI Secretariat as a separate entity from the BBI Steering Committee was not convincing at all and cannot pass. So my finding, the BBI process remained executive-driven, and the promoter of the Amendment Bill 2020 was the President through the BBI Steering Committee. And as a popular initiative is a citizen-driven initiative, the attempt by the President to pursue a popular initiative through the BBI Steering Committee was unconstitutional and unlawful, and to that extent, neither the BBI nor the BBI Steering Committee had the competence to promote the draft Bill 2020. I would therefore uphold the declaration at paragraph 7843 that the President does not have authority under the Constitution to promote a constitutional amendment through a popular initiative, and that the constitutional amendment can only be made through a parliamentary initiative under Article 256 or through a popular initiative under 257 of the Constitution. I would set aside the declaration at paragraph 784 Roman 4 and declare that the BBI Advisory Task Force and the BBI Steering Committee established by the President were not unconstitutional or unlawful entities. I would partly uphold the declarations at paragraph 784, Roman 5 and Roman 6 and Roman 8 to the extent that the BBI Steering Committee, though not unconstitutional or an unlawful entity, had no legal capacity to promote constitutional changes under Article 257 of the Constitution, and consequently, the promotion and launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. So I don't want to repeat. I just want maybe just to highlight a few of my findings on some of the other areas that I have not talked about. On presidential immunity, I have analyzed this in my judgment, but my analysis is substantially the same as what my brother Judge Gatembu has already stated here, so I will not read it. But my finding is that I would uphold the declaration at paragraph 7842 of the judgment and the findings of the learned judges that the President is subject to civil proceedings during the tenure of his office whenever he acts outside the parameters of the Constitution or omits to do that which he is bound to do under the Constitution. And then I would also find on the issue of service upon the President that the President was not served with a petition filed by the 78th respondent, nor was he personally served with a hearing notice. His right to a fair trial and right to natural justice were contravened, and the learned judges were wrong in making adverse orders against him personally. I would accordingly allow Civil Appeal number 294/2021 and set aside the adverse orders that were made against the President in his personal capacity. I'm in agreement with the majority in regard to each of the issues that I have not fully addressed in this judgment. And for avoidance of doubt, I want to say that I specifically adopt the reasoning and conclusion of the majority in regard to the fact that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission, that the IEC does not have the requisite quorum for purpose of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill, and that at the time of the launch of the Constitution of Kenya Amendment Bill and the collection and endorsement of signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor an adequate legal/regulatory framework to govern the conduct of referendum. That the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum and in violation of sections 5, 6, and 11 of the Statutory Instruments Act. That the county assemblies and parliament cannot, as part of their constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution. That the second schedule of the Constitution of Kenya, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function, is unconstitutional. That is a function of delimitation, is unconstitutional. I am also in agreement on the issues regarding whether the issues before the High Court were moot or not justiciable. I am in agreement with what the President has stated on that. I'm also in agreement on the issue of the amici, and I fully adopt the reasoning of the majority on the cross appeals and concur that these cross appeals should be dismissed. On the issue of whether under Article 257.10 of the Constitution, all the specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions to the people, I am of the view that the Constitution requires that the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. So, in conclusion, I join my brother and sister judges in appreciating the senior counsel and all counsel who appeared before us. The wealth of knowledge, high level of professionalism, and commitment that was displayed by all was prodigious and is commendable. I also recognize the invaluable support that I have received from Irene Chege, my legal researcher, and Harriet Gasheri, my secretary, who worked tirelessly behind the scene to ensure that I had my judgment ready in time. The issues that were raised in this appeal have led to a significant conclusion because it is a practical demonstration of judges in appreciating the senior counsel and all counsel who appeared before us. The wealth of knowledge, high level of professionalism, and commitment that alive. The final orders shall be as stated by my brother Musinga, President. Thank you.
Thank you very much, my sister, Lady Justice Okwengu. I will now request my sister, Justice Nambuye, to deliver her judgment.
Thank you very much, Honorable President. The challenge is coming to us almost at the tail end. The issues were common, and what is different is actually the presentations. I think for this reason, I will not go through each and every item arising from the common issues. But may I start by appreciating the leadership of our President. May I adopt the summary that he gave out at the beginning of the deliveries. May I appreciate the brotherhood and the collegiality of the members of the bench who have worked as a team. And the approach I take is because of what I have already mentioned, that the issues were common, and what differs is actually the presentations. I will not go into detail. I will just pick out a few items. The major complaint on why the appellants thought that there is no provision for eternity clauses in our Constitution. Then my own brief comments on that. A brief comment on the constituencies in the amendment bill. Give a few highlights on the principles on legitimate expectation. These were touched upon by my sister, Judge Fatuma Sichale. And then mention briefly on the complaint that had been raised with regard to the need for the trial court to call to the President or the authorities that were responsible for the PPI initiative to give an account of public funds involved. And then in a sentence or so, make a mention on the role of MSI, and then the good work and the industry of the legal minds involved. My first observation on the complaint about the application of eternity on alleged existence is not coming. Hello? Okay. On alleged existence of eternity clauses in the COK 2010, appellants submit
Can we get some assistance?
Thank you. On alleged existence of eternity clauses in the COK 2010, appellants submit that an eternity clause is an actual constitutional provision expressly made in the text of a country's constitution declaring some provisions unalterable and irrevocable, which clauses are, according to the appellants, aimed at protecting a specific country's provisions of specific purposes. Among examples numerously highlighted were Article 79(3) of the Basic Law of Federal Republic of Germany, which expressly bars amendments to provision concerning the federal structure and to the basic principles laid down in Article 1 and 20 of that institution. And there was also mentioned an example of that the democratic and social setup, owing to the bitter experience of the Nazi era, intended to safeguard against a repeat of the atrocities perpetrated by the National Socialists, and many other examples were given. and my own comments on reaction or my observations is that on the alleged existence of eternity and an amendable clauses in the COK 2010, the position I take is that taken by the appellants, that these do not exist. Reason being that in jurisdictions where these are found to exist, going by the examples highlighted in the appellant submissions, they are expressly provided for in the respective jurisdictions' constitutions. A proper construction of the COK 2010 based on a proper application of the principles for interpretation and construction as highlighted above in the assessment leaves no doubt in my mind that these doctrines have no application in Kenya. That is why the people reserved in themselves the power to amend the COK 2010, which in my view includes the power to overhaul, as they did with the former constitution, or partially amend it subject to compliance with the prerequisites of the amendment power. Second, going by the guiding principles in Article 10 of the Constitution, there is nothing therein to suggest that the Kenyan society will remain static in its lifespan, so as to stick to the value system as obtained at 2010 when the COK 2010 was promulgated. Good prudence would demand that there be constitutional changes which would in turn inform changes in the law to meet societal needs as and when such needs arise. And on the issue of the constituencies as contained in the halted amendment process, I associate myself with what my colleagues have said, but for purposes of the record, I think I have something to say. My comments is that Section 10 of the impunity bill proposes to amend Article 89 of the Constitution on delimitation of electoral units to increase the number of constituencies from 290 to 360. The impunity bill also attempts to delimit the extra 70 constituencies in violation of Article 89 of the Constitution, violates the principles, procedures, and the safeguards for the delimitation of electoral units. Section 10 of the impunity bill, as read with the second schedule thereof, seeks to defeat Article 892 of the Constitution by compelling IEPC to delimit boundaries before the time set by the Constitution and without going through the procedures and safeguards set out in the Constitution. The impunity bill also usurps the authority of IEPC to delimit electoral boundaries by providing the number of electoral units to be delimited. This indeed is in contravention of the COK 2010. And I think I will highlight in briefly the principles on legitimate expectation as was held in the Republic versus Kenya Revenue Authority ex parte check distributors limited, civil application number 359. The cornerstone of legitimate expectation is a promise made to a party by a public body that it will act or not act in a particular manner. For the promise to hold, the same must be made within the confines of the law. A public body cannot make the promise which goes against the express letter of the law. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way or the public body wishes to treat him or her in a different way. It is a requirement that for the doctrine of legitimate expectation to be successfully invoked, the expectation must in the first place be legitimate in the sense of an expectation which will be protected by law, and there are various authorities which I have also indicated. In other words, since the doctrine of legitimate expectation is based on consideration of fairness, even where benefit claimed is not procedural, it should not be invoked to confer an unmerited or improper benefit. There are also case law. For the sake of time, the answer, this is in answer to the cross appeal of the 15th respondent. And the answer is in the negative, as PPI's invitation for public input on the policy issues involved made no mention that any requests or recommendations by any participating entity would be taken on its face value. Lack of such an assurance prima facie donated discretion in both the task force and the steering committee to choose what to include in the end product action plan and what to leave out. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way, and the public body wishes to treat him in a particular way. So I agree with my brothers and sisters who have dismissed the cross appeal. I will mention shortly about the complaint on accountability with regards to the publication of the PPI Steering Committee to publish or cause to be published details of the budget and the public funds allocated and utilized in promoting the impugned bill. I associate myself and I agree entirely with the reasoning and the assessment of the judges after construing Article 35 in conjunction with the provisions of Access to Information Act 2016. I find that the cross appellants did not follow the correct procedure to seek that information from the litigants before coming to court to have them enforced in their favor. And I also join my colleagues in commenting the good workmanship, the respect amongst the senior and the junior, and the respect both ways. And I think if we continue this way, we are going to put the legal profession here on the world map. I had never experienced such calmness, such respect for the 44 years I have been on the bench. Thank you, Mr. President.
Thank you very much, my sister Justice Nambuye, for your good summary. Now, for purposes of record, I want to say that I carefully summarized all the submissions that were made before this court by all the parties, and I will not read that. And I identified 21 thematic issues, which I will just read them and give you my brief views on each, after which I will then deliver the final orders of the court based on the findings of each one of us. So the thematic areas that I identified and which we have addressed variously in our judgments, hearing committee and the BBI task force report in the Constitution amendment process. Number 4, whether the proposed amendments as contained in the Constitution Amendment Bill 2020 were by popular initiative and whether there was public participation. 5, whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative. Number 6, whether the IEBC a requisite quorum to carry out its business in relation to the amendment bill. Number 7, the role of the IEBC in Constitution amendment by popular initiative. Number 8, whether the IEBC was under an obligation to conduct a nationwide voter registration exercise and the verification of signatures. Number 9, whether the proposals contained in the Constitution Amendment Bill are to be submitted as separate and distinct referendum questions. Number 10, whether the High Court